আদালতের উপরে ভরসা এখনো মানুষের আছে। হ্যাঁ, এই রাজ্যে যেখানে প্রতিবাদের অন্যতম মুখের কণ্ঠ রোধ করা হয়, সেখানে একটা ন্যায়ালয় আবার প্রমাণ করে দিল যে জাস্টিস ক্যান বি ডিলেড বাট নট ডিনাইড। প্রশ্ন হলো, এই রাজ্যে সত্যি প্রতিবাদের মুখ বন্ধ করতে চাইছিল এই কেস ডক্টর আনিকেত মাহাতো, যে আরজিকর কাণ্ডের অন্যতম প্রতিবাদী মুখ, সেই অন্যায়ের বিরুদ্ধে গর্জে ওঠা কণ্ঠকে শান্ত করতেই শাস্তি স্বরূপ তাকে রানীগঞ্জ মেডিকেল কলেজে পাঠানো হয়, যা ইতিমধ্যে ফাঁস হয়ে গেছে কলকাতা হাইকোর্টে। নিজের প্রতি অবিচার হতে দেখে আদালতের দ্বারস্থ হন ডক্টর অনিকেত, আর আদালতে কেসটা উঠতেই কার্যত রাজ্য সরকারের মুখ পুড়ছে। এই কেস নিয়ে বিচারপতি বিশ্বজিৎ বাসুর যুগান্তকারী রায়দান দেখুন।
In the present case, the state, following the mandate of the said SOP, has posted 869 out of 871 candidates in the hospitals opted by them at the time of counseling. But such mandate has not been followed in the posting of petitioner and another candidate. And in doing so, the state has compromised with the merit, in as much as Dr. Antara and Danki, having merit rank 26, and Dr. Triparna Chattopadhyay, having merit rank 34, have been posted in the hospital opted by them at the time of counseling, that is Arjikor Medical College, whereas the petitioner having merit rank 24 has been denied the posting in the said hospital, though opted at the time of counseling. That it is not permissible to the court to examine the validity of a decision, but the court can examine only the correctness of the decision-making process. Keeping such scope of judicial review in administrative action of the state in mind, let me now examine the issue under consideration. A plain reading of SOP clearly indicates that it prescribes a complete mechanism to get the service of SRs during the bond period smoothly and without any dispute. Therefore, it is not correct to say that the said document contemplates two distinct aspects, that is counseling and posting, or the choice exercised during the counseling would not directly reflect in the posting. They say it would suffice to quote paragraph 7A of the SOP to understand the purport of the said document. Then 7A quoted, counseling based on merit list prepared on the basis of collected stated particulars. The SOP without any ambiguity prescribes that posting would be preceded by counseling based on merit. Obviously, such counseling is aimed to achieve the principle of fairness and transparency as held by the Honorable Supreme Court in the case of Bhavna Tiwari Supra. In the present case, the state, following the mandate of the said SOP, has posted 869 out of 871 candidates in the hospitals opted by them at the time of counseling. But such mandate has not been followed in the posting of petitioner and another candidate. And in doing so, the state has compromised with the merit, in as much as Dr. Antara and Danki, having merit rank 26, and Dr. Triparna Chattopadhyay, having merit rank 34, have been posted in the hospital opted by them at the time of counseling, that is Arjikor Medical College, whereas the petitioner having merit rank 24 has been denied the posting in the said hospital, though opted at the time of counseling. The state has sought to interpret the phrase "if offered to me" appearing in the self-declaration of the petitioner to mean that it is the prerogative of the state to offer a seat unless such offer is made. The choice made in the counseling is not binding. This court is unable to accept such interpretation of the said phrase, as it would render the procedure prescribed under the said SOP in the matter of deployment of SRs nugatory. The logical interpretation of the said phrase should be that candidate must secure the merit position to get the offer according to his choice. The state sought to justify the said deviation from SOP also on the ground that the hospital where the petitioner has been posted has a higher requirement for SR in the relevant discipline than the hospital opted by the petitioner. The justification is too feeble, in as much as the deviation, if necessary, should start from the last ranked candidate. The Honorable Supreme Court in the case of Asa Supra has held that higher competition Greater is the duty on the part of the authorities concerned to act with utmost caution to ensure transparency and fairness. It is one of their primary obligation to see that a candidate of higher merit is not denied seat to the appropriate course and college as per his preference. The state has not disputed that it is bound to follow the principle laid down by the United States Supreme Court in the case of William Vincent Vittorelli, but has refused to apply the said principle in the present case, alleging that the SOP, being an administrative instruction issued only to regulate the service of SRs during bond period, lacks the force of law, even of a regulation, as such not enforceable. The Constitution Bench of the Honorable Supreme Court in the case of Sukhdev Singh Supra has held that even if the regulations have not got the force of law, the principle laid down in William Vincent Vittorelli should govern this situation. Extracts from the paragraph 122 is quoted below for ready reference. Then 122 quoted. The SOP is a tool designed to achieve the right guaranteed under Article 14 of the Constitution. Even if the SOP is an administrative instruction, the state is bound to follow the ethos of Article 14 of the Constitution to eliminate arbitrariness in the state action. In the case of Dr. Amjit Singh Supra and Ramanna Dayaram Sethi, the Honorable Supreme Court has laid down the principle that the nature of administrative instruction not having force of law, but the state government could not at its sweet will depart from it without rational justification. The said principle is equally applicable in the facts and circumstances of the present case. The Honorable Supreme Court in B.S. Minhas has laid down the administrative authority is bound to adhere to the procedural standards fixed by it to avoid arbitrariness, failing which the action taken by it would be invalid. The Honorable Supreme Court in the case of Darshit Singh Griwal has held that it is axiomatic that having enunciated a policy of general application and having communicated it to all concerned, the administration is bound by it. Of course, it can, of course, change the policy, but until that is done, is bound to adhere to it. The paragraph 14 of the said judgment is quoted below for ready reference. Paragraph 14 quoted. The decisions cited on behalf of the state are not applicable in the present case for the following reasons. An order of transfer is an incident of government service in the backdrop of the said settled position. The Honorable Supreme Court in the case of S.L. Abbas and in the case of Govardhan Lal has held that transfer made even in transgression of administrative guideline cannot be interfered with, as they do not confer any legally enforceable right unless shown to be vitiated by malafide or made violation of a statutory provision. Those decisions are distinguishable in facts. The case of R. Sai Bharti, though is a factually distinguishable in as much as the matter relates to code of conduct issued by the state government under Article 162 of the Constitution for exercise of executive authority by minister. Nonetheless, the Honorable Supreme Court in the said decision has held that the good ethical behavior on the part of those who are in the power is the hallmark of good administration, and people in public life must perform duties in the spirit of public service rather than assuming power to indulge callous stupidity regardless of self-imposed discipline. In the case of G. Ratnam and others, while dealing with an issue whether a disciplinary proceeding initiated against a railway employee would be vitiated for not following the certain guidelines contained in the vigilance manual, the Honorable Supreme Court has held that such instructions do not have the force of statutory rules, as such do not confer any right on any member of the public to ask for a writ against the government by a petition under Article 226 of the Constitution. In contrast, the state by the SOP has not issued a mere administrative instruction to its servants. It lays down a complete procedure for engagement of doctors to get their service for the bond period. The state is following the said procedure for deploying a set of candidates, but is denying to follow it for two candidates only. The arbitrariness of the state in the said action is on the face of it, and as such, action offends Article 14 of the Constitution. In the case of Upananda Chatterjee, is no pointer to the issue under consideration. The decision of the Honorable Supreme Court in the case of Lohia properties is misplaced in the facts and circumstances of the present case, inasmuch as issue falls for consideration relates to pure question of law to be decided on the basis of undisputed facts. Therefore, doctrine of non-favors has no manner of application here. The petitioner has not made out a case of malafide. Therefore, the decision of the Supreme Court in the case of Ratnagiri and Power Limited has also no manner of application in the present case. Conclusion: summing up the discussion made above, this court holds that decision of the state to deploy petitioner at Raiganj Medical College and Hospital Uttar Dinajpur clearly violates the Wednesbury principle. Thereby, the state has committed a serious wrong which demands intervention. Accordingly, the issue is answered in affirmative. As a result, the impugned notification dated May 27, 25 and the leaks annexed thereto, so far those documents relate to the deployment of the petitioner at Raiganj Medical College and Hospital, Uttar Dinajpur, are set aside. The department is directed to deploy and or engage the petitioner in the second vacancy of the SR in the discipline of Anaesthesiology at RG Medical College and Hospital with immediate effect.